Hi everyone, my name is Kruse. I'm an attorney and the owner of Kruse Family Law located in Minneapolis. Welcome to our series, Basics of Minnesota Divorce. The purpose is to provide a brief overview of some of the topics that pertain to the divorce process in the state of Minnesota. Please remember, I am not your attorney. This is not intended as specific legal advice for you. This is a very broad overview. Do not take action or fail to take action based on what I say today. Always contact and talk to your own attorney before you do anything related to your divorce. We're going through some of the common issues in divorce. Today, episode 8, division of marital property. So what we need to do first is talk about what is marital property and what is not marital property. Now, the presumption is going to be that all property acquired during the marriage is marital. The title doesn't matter. I know people come in and they say, well, we have this house, but it's only in my name. Does that mean that it's mine? No. What matters is, does it fit the definition of marital or the definition of non-marital property? How it's titled does not matter. So, basically, marital property is property that is, and this is the statutory language, acquired by the parties or either of them at any time during the existence of the marital relation, but prior to the date of valuation. And the valuation date is defined as the day of the initially scheduled pre-hearing settlement conference, unless the parties agree to a different date or the court defines that another date should be used. Typically, the valuation date is going to be the date of the ICMC or the initial case management conference. And in Hennepin County, for example, the ICMC is the valuation date by standing order. Now, again, you can argue that another date should be used and the court can consider that, but in most cases, it's going to be the date of the ICMC that is used. So, talked about marital property. Well, what's non-marital property? Non-marital property is really the exclusions from marital because, as I said, the presumption is that all property is marital, and the burden of proof is going to be on the person who's claiming that it's not marital. So, non-marital property means property, could be real estate, could be personal property, acquired by either spouse before, during, or after the existence of the marriage, which 1 is acquired by a gift, bequest, devise, or inheritance made by a third party to one but not the other spouse. What that means is that it has to be given just to you or inherited just by you. Now, with inheritance, that's usually not quite as big a deal, but gift, it can be difficult to prove. Was it given just to you or given to both of you? And this can be the subject of litigation. For example, let's say that your parents gave you $25,000 as a down payment on a house when you got married. Was that intended as a gift just to you, or was that intended as a gift to both of you? If it was intended just for you, it's non-marital. If it was intended for both of you, it's marital. And so you can see where this can become a subject of some litigation and some court fights. If it's something that's acquired before the marriage, it is non-marital. If it's acquired after the valuation date, so in Hennepin County, for example, after the ICMC, then it is non-marital. Could be excluded by an antenuptial contract. So if you have a prenup that says property X is my non-marital property, then it is your non-marital property. And the fifth category of non-marital property is something that's acquired either in exchange for one of these other categories of non-marital property, or it's the increase in value of the non-marital property. Now, exchange, you are going to have to trace this. So an example of this might be you had a house before you got married. When you got married, you sold it. You got $50,000 out of it. You put that $50,000 into a new marital home that now has $100,000 in equity. We're not going to go through all the way of how you figure out exactly how much, but just in simple terms, let's just say that that's what happened. $50,000 is non-marital because you had it before. 50,000 of that 100,000 is marital, but you have to trace it. You have to be able to show it came from this house and went into this house. The increase in value is also going to depend. If it is an increase that is due to passive forces, then it remains non-marital. If it's active, you're using what is called marital effort, that increase is marital. And an example of this, let's say that going into the marriage, you had an investment account. You had some stocks, they were worth $5,000. Now, 5 years later, they're worth $10,000. If you just left that investment account sit, and this is the result of market forces, then that increase remains non-marital. But if you were actively trading stocks during the marriage in this account, well, now you've used marital effort and you've turned that increase into marital property. So we've got marital, we've got non-marital. How do we divide that marital property? The property division is to be, in the words of the statute, just and equitable. This does not mean that it has to be equal. Okay? Equitable is not necessarily equal, although in practice we often do equalize the marital estate. And we do that typically by creating a balance sheet of assets and debts and trying to equal it out between the parties. But do keep in mind that that is not necessary. It does not have to be equal. So what are the statutory factors involved in property division? Well, there are a number of them, and these are a few of them. The length of the marriage, the age and health of the parties. For example, somebody who's in poor health may receive a disproportionate share because they're going to be less likely or able to acquire additional property after the fact. The occupation and the amount and sources of income are going to be important. If you have one party who is vice president of a corporation and the other party has been a stay-at-home dad or a stay-at-home mom, well, then that stay-at-home parent might get a larger proportion of the property because they're not going to have the same opportunity to get additional property as the years go by. Your vocational skills and employability are going to be important. Let's use that same couple. One was a corporate vice president, the other one was a stay-at-home dad or a stay-at-home mom, and you've got retirement assets. Well, that stay-at-home parent might get the lion's share of the retirement assets because they don't really have a good way to build up retirement assets going forward, whereas the vice president does. The needs of the parties are going to be important. If one party has physical limitations, and this relates back to health, but physical limitations that mean that they have to spend additional money. They have to have a special van that they can drive because they're unable to drive a normal one. They have to retrofit the house to accommodate a wheelchair, things like that. They may get more of the property to be able to cover those things. And the opportunity for the future acquisition of capital assets. Again, this relates to these examples that we have been talking about. Now, in addition to assets, you always have debt. Well, not always, but usually have debt. And debt is going to be allocated in the same way as assets. Right? The allocation of debts should be just and equitable. Again, doesn't mean they have to be equal, but it should be equitable between the parties. Things that you might consider when you're talking about debt and the allocation is who is better able to pay. Again, going back to that example of a corporate executive and a homemaker, the executive is likely to have more income and is going to be better able to pay those debts going forward. Why were those debts incurred? For example, it was something that only benefits the person who incurred it, and the classic example of this is a student loan. It's generally going to be paid by the person who incurred it. And so typically we put student loans onto the person who took them out. Not always, but typically. Excuse me. And another possibility is that you incurred a debt without the knowledge of the other party. If that occurs, then the person who incurred the debt may be saddled with it because the other party didn't even know about it. We put the debts on the balance sheet and they offset the assets, and we try to come up with an equalization, usually at the end. Again, it doesn't have to be equal, but that's often how we do it. I know that this was a very quick overview. If you have additional questions, please do get a hold of us. Take a look at our website, krusefamilylaw.com. There are going to be resources on there that may be helpful to you. Give us a call, 612-231-9865, or send me an email, corwin@krusefamilylaw.com, and I'll do my best to get back to you. Hope you found this useful and interesting. Thank you for watching. Have a good day.